So hello everyone, it's a great pleasure for me to welcome you to the final panel of our conference here at Glasginburgh on distribution and the responsibility of private actors. I think some of our discussions that we had in the roundtable will hopefully also feed into some of the very important debates that our panelists are bringing to the table in this session. So I'll begin by introducing our speakers. So first we'll hear a presentation from Kinnari Bhatt, Dr. Kinnari Bhatt, who will be talking about distributional concerns within transnational development projects. Kinnari is a legal practitioner and academic and is currently a senior legal advisor working on project finance, climate finance and sustainability at a Japanese cooperative bank based in the Netherlands. She also serves as an international law expert on Indigenous people's rights and land rights with the independent redress mechanism of the Green Climate Fund in South Korea. After obtaining her PhD, Kinnari worked as a postdoctoral researcher at the Erasmus University Rotterdam, where she authored her monograph, which will be being discussed in this presentation. Kinnari has many years of experience working as an emerging markets project finance lawyer with global law firms in London and Asia, and has acted as a legal advisor to the Ministry of Mineral Resources in Sierra Leone. Our second speaker today is Dr. Irene Couzigou, and her presentation will be on securing information technology, the need for a collaboration between states and private actors. Irene is a senior lecturer at the University of Aberdeen Law School. Her research focuses on international peace and security, especially international cybersecurity law, international law on the use of force, and United Nations law. She has published extensively and presented at numerous international conferences in those fields, and her current research addresses the status of states and private actors in cyberspace, more particularly their possible cooperation in securing cyberspace. Our third speaker and presentation will be Margarita Brunori, Dr. Margarita Brunori, who is a postdoctoral research fellow at the University of Trento in Italy. Margarita will be presenting on FAO and OECD guidance on responsible food chains, pros and cons of increasing regulation of social corporate responsibility in the agri-food sector. Margarita is specialized in food and agricultural law and national resources governance. She is currently working on the project Sustainable Food Platforms, Enabling Sustainable Food Practices Through Socio-Technical Innovation in the Department of Sociology and Social Sciences. Within the project, she is looking at the legal framework regulating digital platforms for the purchase of food products in the EU. Previously, she has dealt with issues of access to natural resources and human rights, and the role of international standards regulating the behaviour of states and private actors, and she continues working on the subject with a project on the UN Declaration on the Rights of Peasants. So that's by way of our introductions. Just a quick note to say that we are recording this session, so if you do not wish to appear, then please keep your camera turned off. With that, I'll hand over to you, Kinnari.
Thanks, Anna, and thanks to all the organisers for hosting this event, Deirdre as well, to Gail. Luckily, it was a bank holiday here yesterday, so I was able to listen to the keynote and one of the other sessions, so that was really nice to get a bit of an insight into what you guys are talking about. But I fear that I'm not critical enough for you, so we'll I think we're going to have to see how it goes. First of all, I don't really have any slides, apologies. Haven't really had the time, but what I'm going to do is I'm going to really kind of talk through my approach and discuss the book that I wrote it's about a year ago now, and my observations on, redistribution and transnational development projects. So I'm going to start first with a kind of a macro zoom out to locate development projects and my approach in the first part, and then I'm going to zoom into some of the themes from my book. I had thought of talking about the recommendations, but I don't think I'm going to have time. So if anyone's interested, you can just pick up the last chapter of the book and have a look. So zooming out, do private actors matter for redistribution and rights? Well, I think hopefully we're all here and we all agree that resoundingly yes. At the moment, they're coming into really sharp focus now on debt suspension initiatives. Jubilee Debt Project has been doing a lot of work on this, obviously Eurodad as well. Problem with these initiatives is that they're only really looking at sovereign debt bonds. that are incurred under bond issuances, and they exclude the billions and trillions of dollars that governments owe to private creditors as a result of the kinds of development projects that I'm going to talk about. So we don't have to look very far to see the impact of development finance and public-private partnerships on rights, and how debt burdens will frequently bear on the shoulders of those least able to bear that burden. So development projects are, of course, part of this market-driven Washington Consensus economic development parlance, which presents industry and infrastructure as a type of indistinguishable modality for foreign direct investment in two key areas: primary industries for natural resource development, and the construction and operation of asset infrastructure projects. And these projects, of course, prioritize private property rights, which is the rub, as the tool to accelerate these two kind of behemoths of development. So obviously conflicts are going to ensue when those private property rights encounter the pre-existing collective rights of Indigenous people to the same parcels of land and water. So, what is development finance? When I look at it, I think nobody can kind of keep a straight face and say that it's not part of the neo-colonial project. I think it's hard to dispute that. You only have to look at, how the CDC, the Commonwealth Development Corporation, used to be called the Colonial Development Corporation, to get a kind of idea. And I work in this sector, we're all very aware of what this project is. The issue is that development projects, I think, are only going to get more and more proliferated. And this is because of the SDG agenda, which presents them as a really kind of silver bullet for addressing all the inequalities, social exclusion, to the distribution of vital public services to underserved communities. There's also a developing state, post-conflict state nexus here. So, when you have post-conflict states that are in really precarious positions of having constitutional and legal duties to their citizens, while also seeking to signal an enterprise-ready attitude to donors and to DFIs in order to incur capital investment and develop a tax base. So I'll be honest, when I started my academic journey, I was looking for studies that looked at this kind of approach, and I couldn't find any. What I did see that was lots of, principles. We know that law is not autonomous from capitalist structures. We know that, that private actors and private contracts are part of law's informal empire from Koskinyemi. We know these things, but I was, wondering who is asking about what private legal devices do in projects and how they impact the visibility and implementation of Indigenous rights. So I think we're getting there. We're getting, some great scholars. Katerina Pistor is now talking about the coding of capital. Some, human rights scholars are beginning to look at these issues, Indigenous and business human rights. But I think there's still quite a few gaps here. I think currently business human rights scholars, they're very interested in substantive equality, that's been achieved through, for example, due diligence processes or consultation processes. But there doesn't seem to, there's quite a bit of ambivalence, I think, to really look further than that and ask, how is this substantive equality being achieved, or how is it being eroded? And I think you can only do that if you really deep dive into the contracts and the money flows, without which these projects just would not exist. And of course, the largest global value chain around, which is the global financial markets, and what they actually do to communities, even though it's like a butterfly effect, right? So what they do to communities at a micro level. So my kind of nervousness of coming onto this panel was that, my approach may not be revolutionary enough to some of the critical legal scholars. There might be an accusation that I'm further embedding the status quo through improvement, but I stand my ground. And, I've kind of taken a lot of inspiration from people like Patrick McCausland, who had a view of looking at public and private actors in a in a way that's less about competition, but more about reforms that include practical participant rights compatible outcomes. And that's obviously, quite a mouthful, and it's very loaded, all those terms. But, I don't want to be the kind of aloof critic. And the idea with this book really was to make some concrete recommendations and to do quite a lot of fact finding as to what's going on a micro level. So I'm going to now zoom in a little bit. So there are quite a few themes that come out in the book. So I'm just going to map a few of them, and they might be a bit random, but here we go. Arbitration and ISDS, investment dispute. So one thing I did notice with international economic lawyers is that there's almost an obsession with formal treaties. Now, bilateral investment treaties and the whole regime. Now, this is a really important area, but it's only one part of the puzzle. And I think that if you really want to get serious about issues of, development projects, development finance, redistribution, inequality, it's probably a good idea not to forget the contracts that choose that forum and stipulate the rules of the game for the development project, and which those arbitrators are going to pick up and they're going to review and they're going to look at when they're making those awards. So that's one point. Similarly, there's a lot of attention to performance standards, DFI performance standards, the IFC, and there's so many of them now. They're nice, but they're only part of the picture for understanding the exclusionary impacts of development projects. So what I kind of flesh out in the book is, I hope, is that these kind of ISDS and these performance standards are really only moments, right? They're moments of a much longer and a more complex process of whatever you want to call it, transnational legal ordering, or transnational law, or global law. Well, maybe not global law, which presets the legal power dynamics in favour of private interests long before arbitrators or lenders will ever even come into the picture. So what do these rights and structures and behaviours have to do with public rights and expectations? Well, a lot. And I navigate them in my book with reference to a number of examples. But just to give a few in the time that I have, state delegation to private bodies. So human rights scholars have in the past referred to this as contracting out or rollback of the state. Jennifer Lander, in her recent monograph on Mongolia and development projects in Mongolia, talks about it as an entire state transformation. So the state is being, completely transformed in its constitutional role through these development projects. So that's another approach. I don't really have any opinion on where I sit in that. I think it's happening, and I don't think it really matters. But I think what we're seeing then is a direct role being given to private actors in the day-to-day implementation of Indigenous rights to land, which then mutes the application of international and domestic norms. So how is this state rollback or transformation, whatever you want to call it, happening? Well, project structuring, the special purpose vehicle. There's a special purpose vehicle that is formed to construct and operate a project. It's completely insulated from the sponsors. The assets are ring-fenced, and the project then is ring-fenced from general international law principles. Yet at the same time, the state is involved as a minority shareholder in the project. So it's both a duty bearer towards the project because it grants licenses and a concession, and it's an economic recipient of the spoils. So the private participants remain in control, so there is no real formal conferring authority or contract through which the state is controlling or empowering that entity. So when you have to have a look at, what's actually then happening deeply in that paradigm of informal delegation, some practices and behaviours of private actors begin to take shape. So I'm just going to pick up a few of those. One, once a project is structured, participants become really focused on knowing what are called key bankability risks in the early stages of a project, which results in a huge amount of contracts between the SPV and other parties, including the state, through concessions, power purchase agreements, and lots more. So this structuring to me reveals a really deliberate temporal process of development project finance, and provides a systemic explanation as to why these international safeguards consistently fail. And that temporal process is very deliberate. There are distinct phases that I plot in the book during which rights become slowly and steadily destabilized. So even before investment from financial institutions is secured, major constitutional and human rights concerns about land resettlement and other environmental and social issues have been sealed within all of these contracts, the concession, the PPA, and all these major project documents that are signed between the SPV and the government. The financing documents then essentially accelerate that powerful legal position of the concessionaire, which is your project company, over communities through the debt mechanisms. So we have things like high commercial interest rates during the construction phase, which is a really risky phase because that's the one that's most vulnerable to eviction and resettlement. There are lots of other mechanisms, for example, in the construction contracts that I talk about, delay liquidated damages. And so by the time the DFIs come in with the safeguarding standards, the cake really is already cooked. So in total, the contractual framework puts the concessionaire into a priority legal position where they can make choices about clearance, and they can determine who a social consultant or anthropologist that they're going to hire will be to determine even whether the Indigenous performance standards will apply. And this brings me to the next theme, which is discretion. So within this ring-fence structure, the power of financial institution and sponsors to take decisions which will have a type of a butterfly of impact on communities within a project becomes highly concentrated. So we have lots of practices, labeling of groups as vulnerable as opposed to Indigenous. That's actually now become very common, and I've actually recently been asked to review an article which is looking at this and demonstrates how many projects have been invested in where Indigenous people are involved, and yet the performance standards are not applied. So this is a direct result of these power dynamics that are happening because someone, and I know who, but somebody somewhere is just making these determinations. So I think Deirdre talks about this in a kind of astute concept of tide effectiveness, in which the World Bank creates a space for tying and untying communities and labeling them as affected. And I would say, looking at Gigi's work, that this tide effectiveness is fundamentally enabled by these technical legal structures of contracts, policy, behaviour, and the discretions that permeate. The other kind of mechanisms that I discuss include pricing of electricity tariffs, for example, in the Bujagali project in Uganda, various hiring of NGOs, local NGOs, to conduct resettlement and then to do the compliance review of that practice, which is actually bonkers situation, given the obviously conflict of interest, and deficiencies within the process of specific redress mechanisms of some DFIs. Some DFIs do a much better job than others. And there are reasons for that. There's reasons as to what their mandate is, but also how people are selected onto that panel, and the independence and power they have within that institution to actually make change. And those are all very opaque things, but they have an impact. And of course, there are many other examples from loans and concessions that I talk about. So, I mean, essentially, just to wrap up, I feel that my book comes to it makes quite a few recommendations directed at the state, at international organisations such as development finance institutes. They have a huge amount of power and they have a huge amount of leverage to make some practical change in these structures. I think one thing we should all be asking ourselves is, for example, should these category A DFI projects, equator principle projects, should they even be financed? They should not be financed. So none of these, issues will come into scope. So I think that's, one question. There's a need to start. I think all of this as well is essentially it's a basic design failure. So everything is being pushed further and further downstream. And I think, with the design of national laws that are specific to development projects, with a blind trust mechanism, which is one thing I look at in my book, looking at how a blind trust mechanism can help with the upstreaming of mediation very early on. I think there's various ways in which projects can be, have better outcomes. So, yeah, I mean, that's essentially my take on development projects. I've had some interesting feedback from my book over the last year, and yeah, I think, very happy to take any questions, and yeah, well, I hope you found it interesting, and thanks for inviting me.
Thank you so much, Kinnari. I think, just the fact that you managed to talk about such complex matters in such a relatable way says a lot. So thank you very much. We will now hand over to Irene. Yeah. Irene, I'm not hearing you.
Irene, I think you're on mute.
Okay, sorry for that. So I will talk about the need for collaboration between states and private actors to secure cyberspace or to secure information technology. But first, I would like to have a focus for my paper. So what do you understand with securing cyberspace? For me, securing cyberspace has two elements. First, the suppression of online content that encourages the perpetuation of attacks, whether it is in the cyber or physical world. So I refer to, in particular, to terrorist content online that should be suppressed. And a second element of cyber security is the reaction to cyber attacks. So more and more states are relying on private actors, so namely on IT corporations, to secure cyberspace because they don't have the technical means or they don't have the human materials to do that themselves. So they are delegating the public function that is to secure a space, whether it is a cyberspace or physical space, to private actors. So first, they are delegating more and more the task of suppressing online content that is harmful, such as terrorist content. So for instance, Germany adopted in 2017 the Act to improve enforcement of the law in social networks. According to this law, internet platforms such as Facebook, Twitter, and YouTube have to remove hate speech material within 24 hours. And if they do not do so, they face huge fines. At the international level, or more particularly at the EU level, the EU has recently adopted a regulation addressing the dissemination of terrorist content online. This regulation was adopted at the end of April and will enter into force in 1 year. This regulation applies to providers of information society services which store and disseminate to the public information and material provided by a recipient of the service at his or her request. So for instance, social media platforms are concerned by this regulation. Also video streaming services, image and audio sharing services, and so on. This proposal covers not only hosting service providers that are based in the EU, but also those that are based outside the EU, but that offer services within the EU. So I will summarize the content of this regulation. So first, this regulation gives power to so-called competent authorities based in the EU member states to issue removal orders of terrorist content to hosting service providers in all member states. So hosting service providers do have to remove terrorist content following an order adopted by a so-called competent authority. Second, initiatives to tackle terrorist content can also be taken by the service hosting providers themselves. Where a hosting service provider is exposed to terrorist content, this provider shall in particular take appropriate technical and operational measures or capacities to identify and expeditiously remove or disable access to terrorist content. So the hosting service providers themselves, as private actors, can remove or disable access to terrorist content if they are exposed to terrorist content. So what does it mean? According to the regulation, a hosting service provider shall be considered to be exposed to terrorist content when informed so by the competent authority of a member state. So it's a competent authority that gives the qualification of being exposed to terrorist content to a hosting service provider that then has to take several measures to address terrorist content it may host. So this regulation has provisions that try to protect human rights, but other provisions, and it will be exposed in my following slide, do raise concerns concerning human rights. So as we all know, the EU, of course, is bound by human rights established in the Charter of Fundamental Rights, and the EU in particular is bound by the right to freedom of expression. This right can be limited if it is necessary to establish or re-establish order and law. So exceptions to the right to freedom of expression are allowed. However, those exceptions should be limited and proportionate to the aim. And the regulation tries to ensure respect for human rights by the hosting service providers, because first, it is said that the measures taken by the hosting service providers must take into account the fundamental rights to freedom of expression and information of their users. So they are asked to behave in a human rights compatible way. Second, hosting service providers shall report to the competent authority on the specific measures they have taken. So they are monitored by a public authority. The competent authority should respect fundamental rights, should be composed of experts in fundamental rights, and should be independent. It is not specified in the regulation itself that the competent authority is a court. That would be ideal. But nevertheless, it is competent and should have an expertise in human rights. The hosting service providers shall set out clearly in their terms and conditions their policy to address the dissemination of terrorist content. So there is a transparency requirement for the hosting service providers. And finally, they shall establish a mechanism allowing content providers, so namely their users, to submit a complaint. Some provisions do, however, raise human rights concerns. First, there is a very, very broad definition of terrorist content in the regulation. So I will not read everything that is on my slide here, but only to show to you the broadness of the definition of terrorist content. So terrorist content in the regulation means inciting the commission of a terrorist offense or soliciting a person or a group of persons to contribute to the commission of a terrorist offense. And a terrorist offense was defined by an EU directive. And what a terrorist offense is also very broadly conceived. So it is, for instance, an attack upon a person's life or integrity whose aim is to seriously intimidating a population, to compel a government to perform or abstain from performing any acts, or seriously destabilizing or destroying the fundamental political, constitutional, economic, or social structures of a country. So actually, I don't think that the content of the regulation, if it was to be implemented by the EU itself or by a state member of, as a member of the EU, would be in compliance with the human rights obligations of the EU. And of course, here there is a risk that a hosting service provider does not act in conformity with the right to freedom of expression, given the broadness of what it should address, namely terrorist content. My second concern concerning this regulation is that, in my opinion, the private actors, so the hosting service providers, are not sufficiently monitored. They are asked to provide one report per year, only one per year, to states, to the competent authorities, more exactly, where they explain what measures they took in order to address terrorist content online. So I think it's not sufficient. So in my opinion, the EU or states must ensure that the delegation of public authority occurs in ways that comport with their human rights obligations. So it means that if there is a delegation, it should be clearly defined and strictly monitored. Security in cyberspace also relates to the reaction to cyber attacks. So cyber attacks are operations in cyberspace that compromise or impair the confidentiality, availability, or integrity of electronic information systems, services, or networks, whatever the objective of the cyber attacker, economic, political, or otherwise. So I have a broad definition of what can be a cyber attack. In practice, unfortunately, states are very often inefficient or slow in detecting or reacting to cyber attacks emanating from the cyber infrastructure within their territorial borders. It is also the case of states that are technologically developed. So even the United States struggle in reacting to cyber attacks, in particular to those that target private companies. Because what states do is that they protect first their own assets in cyberspace or critical national infrastructures, and they do not have the means to protect private companies. So what do private companies do? They react themselves to cyber attacks without any cooperation with states. So the question here I want to raise and try to answer is, should we allow private companies, whether multinational information corporations or private security companies that work for other companies, should we allow them under national law and under international law to react on their own to cyber attacks, because states are unable to do that themselves? So first, I want to explain to you a few words. So there are two ways for a company to defend itself. The first way refers to passive cyber defense strategies. Passive cyber defense strategies focus on preventing unauthorized cyber intrusions. So a typical example is the installation of an antivirus program. So to prevent cyber attacks is, of course, lawful and does not raise any legal issue, whether under national law or international law. The second way of defending itself is to resort to the so-called active cyber defense techniques. They detect, mitigate, or stop malicious cyber attacks. There are two kinds of active cyber defense techniques. First, those that remain in one's network, they are defensive. For instance, a company could use a so-called honeypot to attract a cyber attacker into a system, to identify the cyber attacker, and then to prevent its intrusion into the network of the company. And the second kind of active cyber defense measures are offensive. They are offensive because they interfere into the network of the attacker. For instance, a company may react to the breach of its data and may want to recover its data that were stolen in the network of the attacker. But in doing so, obviously, the company will interfere into the network of the attacker. And this interference is prohibited. So as far as I know, I could not find any national legal system that allows so-called hackback activities. So in other words, cyber defense measures that interfere into the network of an attacker. So hacking back is prohibited, and the question is, should hacking back be allowed? So there are several advantages of hacking back. First, of course, efficiency. Private actors may be quicker and thus more efficient than states to attribute and respond to cyber attacks. A second advantage of hacking back is deterrence. Hacking back has a deterrent effect. So since it may be efficient to react to a cyber attackers may in the future may be more or less willing to attack again because they know they may not be successful. And the third advantage of hacking back is confidentiality. Indeed, companies may be reluctant to allow access to their computer systems to governmental authorities, and therefore they may want to defend themselves. However, there are also serious disadvantages of hacking back. First, the inconsistency in the reactions. Not all companies do have the same technological means, and they may not react in the same way, so there will be for sure an inconsistency among companies, among private actors in their reaction to cyber attacks. The second disadvantage is inaccuracy. Private actors may attribute harmful cyber conduct with a low degree of certainty and may not react with proportionality. So cyber defense should target as far as possible the proper attacker. So attribution should be done with a high degree of confidentiality. And second, the cyber defense action should be proportionate to the attack. And private actors may not strictly respect those conditions. So a certainty or quasi-certainty in the attribution and a proportionality in the reaction. And finally, hacking back may lead to an escalation of attacks and counterattacks at the national level as well as at the international level. Indeed, if a state, for instance, the United States, allows companies to hack back, they may hack back also.
Oh, Irene, sorry, you're muted. We just missed you for a few seconds there.
Yeah, so I don't know what happened. It was not me. It was done automatically, maybe because I'm running out of time. Okay, so the third disadvantage of hacking back is escalation. So allowing private security would lead to, I think, escalation between attacks and counterattacks. So what is the solution then? So I think we should reach a compromise. So we have to be realistic that states are not efficient in securing cyberspace, and companies are already reacting to cyber attacks on their own. And therefore, I think that states could indeed delegate the public function of securing cyberspace against cyber attacks to companies, but only to a small number of companies. And those companies could get a cybersecurity license. So only the companies that are trustful, that have the competence for doing so, could be authorized to secure cyberspace. And the license would have to be recognized at the international stage in order to avoid any tension between states. So all states must agree on allowing hacking back and on which companies could hack back. And private cyber defense should respect certain rules like self-defense in international law. So attribution should be done with a high degree of certitude, and cyber defense should be necessary and proportionate. And those rules about cyber defense should ideally be included in an international instrument, at the beginning a soft law instrument that could maybe become a treaty. And all those licensed companies should be strictly monitored by states. So every delegation should be controlled by the public person, whether a state or an international organization that provided the delegation. So a distribution of public functions between states or the EU and private actors that in my case study takes the form of a delegation is, in my opinion, necessary to ensure cyber security. And a distribution of responsibilities that in my case takes the form of an allocation of responsibilities would also be necessary. So states or the EU should be responsible for insufficient precision in the delegation and insufficient monitoring of the private actors who enjoy the delegated tasks. And the private actors should be responsible for unnecessary and or disproportionate exercise of the delegated task. So thank you very much for your attention, and I look forward to the discussion.
Thank you very much, Irene. So we've already visited two very different areas of international law, but both contexts in which we're seeing that the protection of fundamental human rights very much lies in the hands of private actors. So very, very interesting. Thank you. And if we can now move on to Margarita for the final presentation. Irene, if you're able to maybe close your slides, that would be great.
So, okay, can you see the presentation? Yes. Okay. So thank you, above all, thank you for letting me this opportunity to present my paper, whose title is organization. So it is about the guidance on responsible food chains, released in 2017 by the Organization of Economic Cooperation and Development and the FAO, so the Food and Agriculture Organization. So the title is Pros and Cons of Increasing Regulation on Social Corporate Responsibility in the Agri-Food Sectors. And the objective of the study, which I mainly conducted in 2019, so it's starting to be a little bit old, unfortunately. Are to illustrate the recent regulatory intervention to uphold corporate social responsibility and the respect of human rights from business enterprises. And in this framework, analyze the content of the FAO OECD Guidance on Responsible Agricultural Supply Chains. And then after that, reflect on what are the potential consequences and subsequent dilemmas on the incorporation of this guidance into law. And finally, I will briefly discuss about the potential impact on the progressive implementation of economic, social, and cultural rights in this context. So, corporate social responsibility in the agri-food chain. So I will mainly refer to the European Union environment. So the agri-food chain in the EU is quite a heavily regulated subject. It has since the 60s dealt with issues as rural development and to some extent environment and social security of farmers. So in a way it has the policies contains already elements of social responsibility, but recently the attention has increased on the food chain and especially in the internal dimension of the agri-food chain. So especially the relationship between actors of the food chain and the disparities of power that are often present in the food chain. But what the law still does not capture is the transnational dimension of the agri-food chain. And global food chains, therefore, are not covered by provisions, and therefore the social and environmental impacts outside the EU are not covered. Also, in the EU Commission New Green Deal, corporate social responsibility is aimed to play a role in the new EU agenda, especially in the agri-food sector. So this aspect is to be taken in mind while reading the FAO OCED guidance. More generally, corporate social responsibility developed at the beginning as a purely voluntary action by business enterprises, but it's receiving increasing attention by regulators. So a few examples are the UK Modern Slavery Act of 2015, a French law on devoir de vigilance of 2017, the EU itself adopted a strategy on corporate social responsibility since the 2000 and renewed it, and more recently adopted several directives or regulation that tackles due diligence, so the corporate social responsibility in specific matters. And for instance, the directive of 2014 included for big companies the creation, so the obligation to publish in their annual report a disclosure of non-financial and diversity information. And what's interesting about this new provision is that an EU Commission communication of 2017 trying to interpret and guide companies to fulfill their obligation, it encouraged to use the FAO OECD guidance on responsible agri-food chain to implement the directive. So what has happened is that a non-binding act, but a guidance act of the European Union Commission encouraged the use of this instrument, which is non-binding it itself, to enact, to obey to a legal, a binding provision. So the question that rises is, so how it will be implemented? What are the consequences of this mention? In the framework, something that has to be mentioned is also the fact that about the progressive normativization of social corporate responsibility and the responsibility for businesses to respect human rights is the ongoing negotiation on a legally binding instrument for regulating the activities of transnational corporations. So, provided that this legally binding instrument will be adopted and it will enter into force, the question is how this instrument will be implemented. In a way, what is likely to happen is that states will rely on existing soft law standards on social corporate responsibilities to comply with their international obligations. And in a way, European Union already anticipated this, because so the OECD guidelines are in place since the 70s. They are regularly updated, and in 2011 they incorporated the human right due diligence. But OECD created other more specific sectorial guidelines, such as the due diligence guidance for responsible supply chains of minerals from conflict affected and high risk areas. And how the European Union used these guidelines on conflict minerals, as it is called, is that it is absorbed in a regulation in 2017, which exactly laid down a supply chain due diligence obligation for conflict minerals, for those minerals that come from high-risk areas. So we have seen here, we have a proof that an OECD guidance was used as a basis, and not only as a basis, because their regulation itself refers to the guidelines. So there is a dialogue between the two sources, one non-legally binding and the other yes. So provided that OECD guidances has already been used, and let's say there is an expectation of further regulating on this topic, in a way, in my opinion, it's likely that the OECD FAO guidance as well will have an impact in further regulation. So, so I looked into how the guidelines are structured, and they based the framework on the central topic of the central concept of risk-based due diligence, which is defined as a process through which enterprises can identify, assess, mitigate, prevent, and account for how they address the actual and potential adverse impacts of their activities as an integral part of business decision-making and risk management system. But it also concerns the adverse impacts caused or contributed to by enterprises, as well as the adverse impacts that are directly linked on their operation, products, services through a business relationship. So it creates a vertical line of responsibility, as well as an horizontal line of responsibility. So the guidance contains a model enterprise policies, which contains the core standards, which for time constraint I cannot illustrate, but they refer to procedural standards as well as substantial standards, and they reflect, in a way, they are well done, let's say, because they reflect the most advanced specific standards that has been developed in the last years. For example, they take into account the voluntary guidelines on the governance of tenure. So there is a specific standard on legitimate tenure right. There is a standard on food security, for instance, governance, animal welfare, and environment, and so on. Then the guidance contains the steps and how to articulate due diligence along the supply chain, and provide some more details on how to implement specific standards. So in a way, the guidance is a good reference instrument for the most advanced standard. But we have also to highlight the fact that maybe it's natural that it's this way, but it is totally silent about the importance of small-scale agriculture. and small food producers that we know from increasing work conducted at international level that are of importance not only for their specific vulnerability, so they're important for their specific needs of protection, but also because small-scale agriculture produces food, which is not only meant as a commodity, but also as a commons. So the lack of a reference to this objective that is increasingly recognized creates a vulnerability in the quality, let's say, of this guidance. So very briefly, so let's say that so this guidance is already a reference for European business enterprises in the developing their due diligence plan. So what are the consequences of this being incorporated in the business plans? Or what are the broader consequences of using or relying on those instruments? So that it is likely that companies will rely on private certification schemes for certifying, for enacting their due diligence plan, and that could create or let's say increase, because it's already a phenomenon, let's say, the privatization of norms and the fragmentation of information, whereas what is needed is a stronger awareness and information on the due diligence of business. And another possible consequence is the fact that the due diligence, so the attention, for example, given by the EU regulator on due diligence, let's say, slow down other processes that strengthen the liability or the obligation of businesses in specific sectors. And provided that due diligence is an elastic concept, that risk should not be run in a way that these the creations of the promotion of due diligence plans should not go at the expense of a progressive strengthening of laws that regulate the conduct of enterprises. And another consequence is how the concept of due diligence will be meant and translated into law. Because if we look at the current or already enacted EU regulation or directive that adopt due diligence, we see that there are two different approaches. The first one is a formal approach, where due diligence is conceived as an end. So, for example, the already mentioned directive of 2014-95 on disclosure of non-financial and diversity information, they compel businesses to adopt and share information on their due diligence plan. But in a way, that's it. That's the end, no, of the action. Similarly, the EU regulation on conflict minerals of 2017, it creates a system where importers of minerals and metals should adopt due diligence plans, and they are enlisted. When they do so, they are enlisted in a list of the European Union Commission, and when if they do not comply with this due diligence plan, they are delisted. So in a way, it's a naming and shaming system, where companies are encouraged to have adopt due diligence plan, but actually the consequences are not substantial. They are only formal, in a way that it is delisted from from those who have a plan.
1 minute left, Margarita.
Yeah, I'm finished. So whereas the due diligence as a means reflects a more substantial approach to due diligence, and for example is the approach that is used in the 2010 regulation on timber import, and as well as the 2015 regulation for the compliance measure for deriving from the Nagoya Protocol on access to genetic resources and fair and equitable sharing of benefits arising from their utilization. And in those two regulations, there is an obligation to enforce the due diligence plan, and this obligation is, let's say, connected to so the enterprises have to enforce due diligence in order to avoid liability. So those regulations not only ask for the adoption of a due diligence plan, but they complement the system with a liability, and then penalties are put in place. So, and the consequences for human rights is that so enterprises, business enterprises in any way will have to engage with the content of human rights, and especially if we think about the agri-food chain with the right to food, for instance, as a right clearly involved in the matter, we see that the right to food, as the others, are especially economic, culture, and social right, and their content is evolving. And a clear example, a very important one, is 2018 Declaration on the Right of Peasants and Other People Working in Rural Areas that restate existing right, and in some article they state new right, such as the right to land, the right to seed, and the right to food. And especially the right to food is reinterpreted and strengthened because it recognizes also the food sovereignty, the right to food sovereignty. So what will be the impact of businesses interpreting the content of human rights, and what will respect will mean? It will be do not contribute to the regression of the status quo, or do not obstacle the progressive realization? And lastly, and then I'm finished. So for the Declaration on the Right of Peasant, for example, those rights have a strong emancipatory power. They are a tool that was meant to be used mainly for legitimizing struggles of farmers and peasants and rural communities. What will be the impact of an adoption of the narrative of human rights, and especially those such as the right to food, by business enterprises? So my research ends with those interrogatives, and I hope that met your interest. Thank you.
Thank you very much, Margarita. So I think all of those papers bring out very interesting issues surrounding the regulation of private actors, and I'm very interested to see the dialogue that will hopefully emerge also between the panelists on these critical questions of how private entities can be regulated if we want to respect, protect, and fulfill human rights. So I'll now hand over to Charles Mack, who's going to moderate our Q&A.
Yeah, thank you very much for the presentation. I've learned so much. So we have questions from Chris.
Thank you, and thanks to all of you for 3 really interesting papers. My question is hopefully applicable to all 3, and it was really about something that I thought came out as a thread between them, which is this role of the political masquerading as the technical, and the ways in which lawyers, law firms, sort of experts have then very political outcomes to what appear to be the forefront of technical activities. So in terms of the project finance thing, I'm getting the sense that, you know, with a multiplicity of actors and hundreds of pages worth of documents and different agreements, the amount that gets simply kind of waved through on the basis of sort of boilerplate clauses and standardization, and how much that those choices in there that are hidden affect then the political outcome of what happens in reality in these projects. And I think the same thing hopefully applies to some degree to what Irene was saying as well. When you have a set of real technical expertise in relation to what's happening at the cyber level, the sort of digital technical knowledge that a lot of regulators don't have or have to learn from the private companies themselves that create these things. How much is state authority over these things actually illusory because they're having to rely upon the same organizations that they're trying to regulate to learn about what's happening? And for Margherita, I think that same technical political point comes in relation to some of these choices around what type of regulation, like to what extent things are substantive in terms of due diligence or other types of oversight. It seems that also comes into this question of these are fundamentally look like technical choices of how do you draft a bit of national or regional legislation about how deep you go into it, but fundamentally those choices are political, even though they're not really, I don't think, debated as political issues at the time of putting these things in place. So I just really want to hear from you more about that. But 3 very interesting talks. Thank you.
So I will break the ice. Thank you for the question. Yes, indeed, it is a really subtle line between green washing and social washing and substantively advancing the respect and fulfillment of human rights. I think that in a way, those are the first attempt to regulate behavior of companies. So in a way, it is a learning process. So there has been recently like a switch of mentality, like a progressive awareness of the involvement of companies in human rights, but at the same time, both companies and the legislator still have to find ways to how effectively implement these principles. So and also, so I think that these are let's say weeks, a very soft attempt to introduce the principle into force. That's why, in a way, it should be taken as it is, and therefore it is important not to take it as the end, but as a beginning of a process. And therefore, the attention on strengthening the conduct standards, on the other hand, should be not left behind. I mean, due diligence is not something that should be seen as an end point of this, but just as one of the means through which to enforce and involve private sectors into this. This is my opinion.
Do you want me to answer that as well, give some views? So yeah, I mean, it's a really good question. Law firms have got a big part to play in this, and it really annoys me, having worked in law firms and now, you know, having daily communications with law firms on these issues. You know, what, you know, well, I could, you know, answer your question in 2 ways, the pessimist or an optimist approach, right? So, you know, 6, 7, 8 years ago, none of this was on the table. So it was, you know, it was very easy for law firms to just, as you say, push it through, and didn't really bother about really getting into grips with these kinds of issues. So, you know, when you're talking then about conflicts of interest and, you know, well, yeah, they're all there. And I think it's a financial, a strategic, you know, it's all these, you know, very cynical things. And I think law firms have a lot to answer for that. They would say on their behalf, I'm sure that they would say their clients never asked for it, right? So, you know, but so that's the get out of jail clause that they would have. So it's very interesting now that, you know, we've got a completely different situation. I mean, if you're on LinkedIn and if you follow the legal news, and, you know, wow, it's like we've stepped into a new universe, right? Like where everybody's optimistic. You know, I'm involved with a project called the Chancery Lane project, which is all about, you know, well, precedents, the power of precedents and the power of contract, right? So we know that by setting contractual precedents, you know, the damage that contractual precedents, like you say, has done over the years, right? Because they're based on this neoliberal projects, they've done a tremendous amount of damage. So what can we do now within those contracts, and some, you know, to move the dial, right? Because then the idea is that obviously the theory of change up idea is that yeah, those contracts are used, like they're pushed through, nobody thinks about them, and then hopefully you're pushing through net zero targets, or you're pushing through other, you know, other really good stuff, right? You're changing the design, you're putting in basket trusts, you're doing these things, right? So that's the idea. But I think it's very, very interesting how, you know, law firms now are kind of branding themselves as, you know, the guardians and the shepherds of business and human rights, ESG, all these, you know, nice things. When at the same time, you know, the same departments in those law firms are, you know, acting for companies that are doing, you know, that are facing an arbitration suit, or that are still financing coal projects, or, you know, so, and there's a kind of a lack of understanding, or I think a lack of, maybe it's not even understanding, but I think it's a lack of, they just don't want to talk about it, right? Like what the mechanics do, right? So in hydropower projects, for example, you can have a mechanic that very easily can trigger climate change problems because the way the tariffs are set, right? So it perversely incentivizes a government to, you know, to make sure that there's a lot of water, so that they don't get, you know, punitive damages as a result that are in the PPA. So, you know, yeah, I think it's getting better. And as I say, there's, you know, collective projects like this Chancery Lane project, which is, you should check it out, which is a unique project that I'm involved with, and that, you know, permits lawyers to kind of get together and really do, you know, some drafting that can help, I think, address these issues, because it's confidential, it's not attributable to a law firm and to a person. So yeah, that can actually start to address some of these issues. So that's the optimist in me. But yeah, I think absolutely, yeah, law firms have got a lot to, big part to play in this, yeah.
Okay, any more questions?
Yeah.
If you have any...
Sorry, I can also add something to the question. So you asked me if it is not difficult to regulate IT companies, given that lawyers do not have good IT knowledge. So of course, yes, the answer is yes, but I think the fundamental question is more, do we need to regulate cyberspace? And we are only beginning to regulate cyberspace, because I think we are discovering that we cannot trust IT companies. And therefore, states have to affirm their authority in cyberspace and to regulate the behavior of big IT corporations. But I agree with you that sometimes the IT knowledge of lawyers may be limited, and therefore IT corporations should cooperate with states to regulate cyberspace. So there is an input from the private sector in the normative framework related to cyberspace that is needed. So we need to cooperate because we cannot trust cyber companies. And then, of course, the third question is, if we regulate, we need to common understanding among states, because the United States and China in particular do not have the same conception of sovereignty in cyberspace, but that's then the third issue. If you regulate, then it should be an international regulation, and then, yeah, this is where states struggle a bit to find a common understanding of a future international cyber framework.
So, so Gigi, do you have so we have a question from Gigi.
Thank you very much for all your presentations. So I want to start where Margarita left off and to push a little bit both of you on that, because I think for me that's the crux of an issue about this push towards more responsibility of private actors to respect human rights. So yeah, maybe if I can just push Margarita you further on your last slide, and I also maybe can pose a similar question to Kinnari, because these are the two areas I know a bit more. So how can we then, I suppose, ensure that the human rights themselves don't get co-opted by us demanding private actors to do more with them? If that makes sense, right? Because I suppose what's happening with this push is that we're saying, okay, well, the human rights framework remains as they are, and you guys get the interpretation bit, right? So now you get the chance. So we're privatizing effectively the human rights terrain, right? And because we see that the private actors have too much power for them to not to do this, then it's kind of like a necessary evil for those of us who like the public space, right? To say, okay, then you have to do something. So I suppose I just want to ask for your views. Is there a way of avoiding this co-option? Because I know, Kinnari, you also work about what we can do in order to make private actors themselves be more responsible. So are there ways to ensure that when, say, a company, you know, when they're doing a development project and they interpret what's the scope of Indigenous people's rights, you know, what are the mechanisms, or can there even be mechanisms in place to ensure that that interpretation does not become a more dominant interpretation? So, thanks.
Yeah, thank you, Gigi, so much. Nice to see you again. So first of all, probably a necessary premise to my paper I should have done at the beginning. Overall, I'm very skeptical about attributing business enterprises the responsibility of implementing human rights. In a way, I think that it's the regulator who should create conditions, strict conditions to operate. Not like due diligence should be used with carefulness, because it attributes the responsibility and the agency to the business to decide. So in a way, I'm skeptical. What could be done in a way is that is to ensure that, for example, the code of conduct, so the plans that are enacted, adopted by businesses, but are accurate. Because what could happen is that, okay, they adopt those plans, but they are so they're very broad in a way, and they have effect of social washing or greenwashing what they do, but in fact is just a facade, and it's just some words. So what could be done is to push and probably push also for a learning process in a way that we should be in a way not like at least start with a genuine effort to because some companies are genuinely willing to promote their social and environmental outcome. Just in the way they do so, they're not so progressive in a way. They interpret the concept in their own way. So legislators should let's say, enable a co-learning environment for businesses, but also recognize that businesses have their limit in a way. So what should be done, if you remember my slide where I was saying, okay, do business have to respect, so in the sense of not going backward or leaving the space, no? So for the progressive fulfillment and of rights. So in a way, those boundaries should be set by the state, and also there should be a learning process on how to be specific and punish those who are not specific in their plans, for example, because otherwise that would not be effective and just play at favor of the business. I don't know if I'm clear about it.
Thanks, Margarita. Kinnari, did you want to come in?
Yeah, I mean, so the question is, how do we ensure that states don't co-opt this whole process? Is that correct? Well, yeah, I mean, I think states or companies will not co-opt the whole process. Well, I think we can almost assume that if they can, they will, right? So, and that's what we've seen so far, right? So that is the precedent, right? That is the norm. But the point I'm trying to make is that I think we're at a moment in time, right, where I don't think there's like a linear path to this. It's not like one institution does this, one institution does that. DFIs do this. It's a really hybrid approach, right? And so you need to look first of all, at the state, right? So lots of these states are heavily indebted, right? So then we have to look at, things like looking at private debt, right, and cancelling private debt, right, in order to give the state policy space to breathe, right, so that it can actually do these things. We need technology transfers, right? So these are all very high level suggestions. Which will I think give states more space, right, and more power. Once we can look at that, there's companies. Well, I mean, essentially, the DFIs have a huge role to play, which I think they don't play adequately enough. And I think the pressure is mounting on them to play a much better granular role in this, because they can do a lot, because these companies are essentially their clients, right? So there can be a lot more done by the DFIs to discipline this entire process, and to expect more from companies, so that they set minimum standards. And I think at the state level, then there's lots of things you can do, right? Like there's no regulator for any of this, so special legislation. It doesn't have to be big legislation, right? It can be there can be small memorandums or guiding principles that are specific about development projects, because it's an area that is very hard to capture in a regulatory. It's a big moving target, right? So sets out minimum standards. So yeah, I don't know if that answers your question, but I think I don't think it's a case of looking at it in a linear way, right? Because I think companies will co-opt if they're given a chance. They will take FIPIC and they'll co-opt it, and they will use it for whatever they want to use it for, right? So they'll dismantle it from the UN DRIP, and they'll say that it applies to like benefit sharing, right, and not applying to land, which is what it's used for, right? So, and there are examples of that in my book. So they will do it, right, and they'll carry on doing it. But I think there's a moment where we should potentially be looking at all these issues from a much larger vantage point. It's an impossible question to answer, Gigi. So yeah.
Well, maybe I'll just jump in here and say, unfortunately, we are now 5 minutes over time, and this would, of course, have been the perfect point for us all to go to the pub and continue these conversations over beers or something else. But unfortunately, that is not possible. So I would just like to say thank you so much to all of our final presenters, to Charles also for chairing the Q&A, and for everyone for making it this far. I know we've had a long day on Zoom, so everyone's probably quite tired at the moment. And I believe we have, well, I just see Andrew there raising his hand, and I think Christian also wanted to say a final word at the end. But on behalf of the organising team, thanks very, very much everyone for coming along, and I hope you've really enjoyed the event. We've all enjoyed it very much so. So thank you.
Thank you.
Well, I guess on behalf of all of us then, to you, the organising team, thank you so much. Such a wonderful team. Thank you, Anna. Thank you, Gail. Thank you, Gigi. Thank you, Alex. Thank you, Chris. A fantastic team. This is a really difficult task to put together a big conference like this. Multiple, simultaneous panels at one time. A lot of that work is behind the scenes. Thank you so much for it. And you've done a fantastic job. The tech has been smooth. The conversations have been lively and friendly, and I think the tone of those, very much comes from the tone that you guys set. Thank you very much for that indeed. Have a well-deserved break over the weekend, and of course, to all of us, we're looking forward very much to the next iteration at Aberdeen. Thanks so much.
Thank you. Thank you also, Andrew. We're sharing our thanks. You've said all the words of thanks to the Glasgow team so much better than I could. That all that's left to me is to thank our Scottish colleagues from Edinburgh who initiated this initiative 2 years ago. We've carried the baton onwards now, and I think, as you've heard, it may be carried further by others. So we're all looking forward to this. And to those of you who are joining from outside Scotland, bear in mind this is now becoming a pan-Scottish initiative. International law in Scotland is exciting. Do follow us on Twitter. Do follow us elsewhere. I've certainly learned a lot, even though I've sometimes been absent from discussions, but from reading paper abstracts, and I look forward to the continuation of the discussion. And to reiterate the points that Andrew made, I'm super happy with the Glasgow team that put this all together and organized this so well. Many, many thanks to all of you, and goodbye.
Thank you. Bye, everyone.
Thank you, everyone. Bye.
Bye. Thank you.
Thank you. Bye-bye.
Thank you.